Hello, everyone. I'm Jeff Krasowski, a 1L at Roger Williams University School of Law and president of IPLA, the Intellectual Property Law Association. Welcome to Copyright and Racial Justice. Before we begin the program, I'd like to thank our co-sponsors, Copyright Society of America, especially Bamati, Kate, and Naomi, the Feinstein Center for Pro Bono and Experiential Education, especially Lori, and the Office of Diversity and Outreach at Roger Williams University School of Law, especially Ralph. Special thanks also to Professor Cristelia Garcia for your mentorship and guidance. I'd also like to thank the distinguished panel for being here tonight, as well as the amazing 237 attendees who pre-registered from all over the globe, from India to Canada to Tokyo to UK to South America to Europe, who include professors of law, history, philosophy and music, museum curators, copyright librarians, deans, a president of a college, artists, photographers, musicians, a music festival executive, a legendary mastering engineer, as well as federal judges, practicing IP attorneys from LA, San Francisco, New Orleans, Minneapolis, Miami, Atlanta, New York, DC, and my hometown of Providence, Rhode Island. I'm so glad you're all here. I'll tell you a bit about my journey. After graduating from Brown University in 2006, I was a professional touring musician for a decade in the band Below Anthem. And from that experience, I learned about the power of narrative, and I wanted to think critically about narrative tonight. Intellectual property law protects knowledge, but does it protect and value white knowledge the same as people of color knowledge? Who is the creator and who is the infringer? Is the Euro-American classical composer the creator and the hip-hop sampling artist the infringer? The first federal copyright legislation, the Copyright Act of 1790, afforded copyright protection to any author in the United States, being a citizen or citizens thereof or resident within. Under the Three-Fifths Compromise, enslaved peoples were not treated as whole people, let alone citizens. Thomas Jefferson wrote in his Notes on the State of Virginia that Phillis Wheatley, the first published African-American poet, lacked the capacity for imagination. He wrote, "It kindles the senses only, not the imagination." The compositions published under her name are below the dignity of criticism. Comparing African-Americans by their faculty of imagination, they are dull, tasteless, and anomalous. To take us from Jefferson's remarks to the present day, I welcome four panelists this evening. Anjali Vats is a professor at BC and BC Law and the author of the new book, The Color of Creatorship. KJ Green is a professor at Southwestern Law, has represented Spike Lee and George Clinton, and is an expert on music copyright law. Latif Matima is a professor at Howard University School of Law and founder of the Institute for Intellectual Property and Social Justice. Terica Carrington is VP of Legal Policy and Copyright Counsel for the Copyright Alliance in Washington, D.C. Welcome to the panelists and attendees. Please feel free to put questions in the Q&A at any time. If we don't get to it during the discussions, there will be a Q&A at the end. We begin with a question for Anjali. Anjali, what are the underlying values and ideologies that shape copyright law's racial history? Is copyright race neutral? Why not?
Well, thank you for the question. I want to just start by saying thank you to you, first of all, for putting this panel together. It's such a great group of people, and it's just a really exciting moment, I think, in terms of these conversations. You know, one of the things we were all reflecting on before the panel was how the conversation around these topics has changed, and so I want to highlight that. I just want to start by highlighting how awesome it is that we're able to have this panel and that there are over 200 people here, and let's talk about race neutrality. I would say that one of the underlying ideologies here is one that you point to in what you read, Jefferson's comments. The book that I wrote, The Color of Creatorship, is an approximately 200-year history of copyright law. And it starts in 1790 with Phillis Wheatley. And one of the things that I notice in terms of ideology that shapes copyright law's racial histories is who does and doesn't get to be considered a whole person under copyright law. And this is a problem that we struggle with, I think, nationally, more generally. The question of who is a citizen, who counts as a citizen, how do we treat them as citizens, and so on. But the 1790 Act, as you demonstrated, suggests that there is a distinction, right, between citizens and residents and non-citizens. And we know from the racial history of the United States, that that's a real thing. So I approach these questions as a critical race studies scholar and also as a communication scholar. So some of the methods that I use are drawn from critical race theory and some of them from other spaces. So what I want to say about this is this underlying question of humanness is ideologically shaping intellectual property law in all of its manifestations, as far as I'm concerned. Black feminist scholar Sylvia Wynter talks about this. She talks about, you know, the archetype of man, the ethno-class of man, as Alex Whaley puts it, and who fits in that. And I think what that quote that you read from Jefferson really demonstrates is that there is this dehumanization, literally dehumanization of Black people that excludes them from this category of the creator, or this category of being able to produce copyright law, right? The citizen, the creator, and so on. So I would say ideologically, that's what's happening here. There's an undercurrent of who isn't a human.
Thank you, Professor. And what do you mean that race is calcified in IP doctrine and that the standard of true imagination is racialized?
Mm-hmm. So the way that I was looking at these questions was to think about and look at how there's common language over time. I asked the question of, you know, does race appear in these cases? And if it appears, how does it appear in those spaces? So you asked the question earlier about race neutrality, and I want to start there. I want to say that copyright law is not race neutral, but also I want to explain what that means for those who are not familiar with critical race theory. Critical race theory was an area of law. It developed in the legal academy in response to really was a massive rollback of the civil rights movement. So with the affirmative action cases, with the rollback of Brown, et cetera, in the 70s and 80s, scholars in the legal academy were like, this didn't work out as we imagined it would. So Derek Bell, I think, was one of the first scholars to really say, hey, we need to think about whether this rights-based system, this liberalism based system is really working out the way that it's supposed to be working out. So when we're talking about race neutrality in law, what we're really talking about is whether the language that looks on its face to not discriminate against people actually gets the job done in practice. And what I would say is that copyright law doesn't do that. That if we look at the history of copyright law, what we can see is that there are these phrases, in particular this idea of true imagination that Thomas Jefferson is talking about, that really gets baked into doctrine that is supposed to be race neutral. So when I say that race is calcified within law, what I mean to say is that we can find these fragments of racist ideas and racialized understandings of citizenship and creatorship that prevent us from having the kind of equality that we think and believe exists in law generally, but also in copyright law more specifically.
Thank you, Professor. I invite anyone who has questions for Professor Anjali to submit them into the Q&A now or into the chat. Do any of our panelists have any questions for what she said? If not, would you mind talking about the exception of Prince? I know you bring him up in your book.
I do. I write about Prince in the context of pushback to what is a historical racialization in the context of copyright law. So I mentioned at the beginning that the book covers 200 years. It really starts with Phyllis Wheatley in the context of copyright and says, hey, let's look at Phyllis Wheatley as a starting point for this idea of who gets to be seen as possessing true imagination, and how this idea of true imagination becomes a way of excluding. So what I found was that this idea of true imagination is actually a really consistent one. It's racialized over time. And there's this categorization of true imagination that leaves Black people in particular out, but I think it is weaponized against other people of color. So there's a case about Charlie Chaplin that I would argue demonstrates this. So this is the meta structure of the book with respect to copyright, to think about how true imagination has been exclusionary in cases about race records, in cases about parody, so the famous case of Campbell versus Acuff Rose, in cases about international copyright, here I'm talking about Golan versus Holder, how we really have evidence of this idea of true imagination being an exclusionary doctrinal concept that comes up repeatedly in copyright law. So what does Prince have to do with all this? Well, Prince is I think, very explicitly refusing this narrative. I think that he is trying to create a couple of new narratives that I want to highlight. The first one is really about who gets to be a creator. I think from the outset, Prince made a number of business decisions that marked him as refusing this kind of pigeonholing, the R&B labels or the R&B lists that Black people kind of got pushed into. He didn't want to be in that R&B space. He wanted to be a rock and roll artist for American audiences more generally. So I think in pushing for that, he was really like, hey, Black people are creators, not for a specific audience, but for American audiences and global audiences, period, because they are actually creative. So that's one thing that I want to highlight about him. And the other thing I want to highlight is that I think he was making a really explicit critique of contract law as well. So I love this quote about Prince where they talk about when he changed his name to the love symbol. And, you know, I remember being a kid in the 90s and no one really knew what to do with that. I mean, I think there were some people that knew what to do with that, but they were like, okay, this is weird and why is this happening? And I, you know, as I started to read about it, Prince was really, I mean, the thing he was upset about was exploitation by Warner Brothers and labor exploitation in particular. And, you know, he spent a couple of years, or he spent a few years really fighting this battle to own his master records. So part of the battle he's fighting is also about ownership, this question of who gets to own rights and who gets property rights in the United States. He really wanted to get out of this contract with Warner Brothers. And my favorite quote is, and who knows with Prince whether it's myth or lore or fact or how it really works, but there is a quote that I read about how he went through lawyers like underwear in those days because he really just wanted a lawyer that would be like, yes, you can change your name to a symbol and get out of this contract. But of course, you know, that's not how that's not how contract law works. So this Prince example is really an example of how one example of how musicians, Black musicians, Black artists have pushed back around this really exploitative system and the narratives of creatorship that anchor it. I could give you a lot more explanations or examples. I think other people will be talking about some of them. For instance, Lady Antebellum, I think, is another really visible example in this moment.
Professor, we have a question from Professor Castalia Garcia. Hi, Anjali. Do many of these frameworks and limitations apply similarly to female creators?
I would love a little bit of clarification. So these frameworks, I don't know, Castalia, if you can hear me. I'm going to say the answer. I'm going to say the answer to that is absolutely yes. So the example of, I mean, I think Prince is a good example of gender in one respect because he's really negotiating questions of gender. But I think we can, in the ownership context, we can think about Lady Antebellum as a good example of how gendered ownership works. The example I get into great detail about, if you saw SNL with Chappelle this weekend, you know, they did this whole skit on trademarks getting fired, which I found to be totally fantastic because, you know, there's that line in there that the one thing slavery offers, the one benefit is job security, right? So I was going to point to Aunt Jemima, not in the area of copyright law necessarily, but, you know, Aunt Jemima is this really interesting example of how ownership works. And in the book project I'm working on right now, I'm kind of tracing that example through the legal history of privacy. So privacy is an area of law that disparately applied to white people and people of color, in part because, and here's this idea of humanness coming up again, because there was this belief that white people had an interiority and people of color did not have an interiority, right? So Aunt Jemima becomes an example of this. She doesn't get to own her own likeness, and we see this repeated in cases over and over again. There's actually an example, an unfair competition example, where there's a white woman suing for the rights over Aunt Jemima. And I think that's a really good example of what you're talking about here, both in the trademark and this unfair competition / copyright / privacy area. So yes, the answer is yes, and that gendered disparity is evident in a lot of different ways.
Professor, you have another question here from Alpha. Hey, Alpha, he's in my class actually. He says, can you speak about the theft of indigenous knowledge in production?
So we're mostly focused on copyright today, so I didn't really talk about the patent aspect of this, but part of the book traces this. It looks at the question of how indigenous peoples have been dispossessed of knowledge. And I think one of the ways that works is through the language of expertise, through the framework of expertise in the context of patent law. So indigenous people, and I'll take a step back here and say, you know, one of the arguments the book makes is about racial scripts, about the way that racist stereotypes that we have against one group of people can get used for other groups of people as well. So in the context of indigenous peoples, there is certainly this idea that indigenous peoples are not whole people, but also that they're not experts. So they are stripped of this capacity to participate in the trajectory of patent law, this trajectory of human progress more generally. And I think that plays out in the 1990s and beyond in cases about biopiracy. So neem oil, turmeric, these were sources of great controversy because there were scientists in the United States that were trying to patent what originated as traditional knowledge. And the way that this ends up playing out in some instances is that you have countries really trying to push back against this. So in the context of India, if we talk about indigenous Indian knowledge, India as in South Asian, the Indian government created a database to establish prior art to block patents. But we could talk about this more generally. We could talk about indigenous peoples. We could talk about repatriation of knowledge. We could talk about the Navajo Indian Urban Outfitters case, where Urban Outfitters decided to put Navajo print on underwear and sell it, and they got sued for that, right? There's lots of examples, I think, of the dispossession of indigenous peoples that intersects with intellectual property conversations.
Thank you, Professor. I think we have time for one more question during your segment. I've got one from Nicole here.
Great.
Can you speak to the development of work for hire within the copyright code as a potential vehicle for emphasizing the ideas of the citizen creator?
This is a good question. Works for hire. This is not one I have given a whole lot of thought to. So, you know, I want to point out what the labor politics of works for hire, and I think labor politics are always raced and always gendered. But you know, when we're talking about works for hire, we're functionally talking about contracting, and we're talking about contracting out certain kinds of labor. So I would, I guess, structurally start there, and I'm just you know, spitballing here. So I would start with that question. If I were looking at a case that involved a work for hire, if there was an exam question, for instance, that had a work for hire on it, I might say, well, what are the labor problems with this? And I think one of the labor problems that we're talking about is, I think, a thing that KJ is going to talk about, which is unequal bargaining power. So if you are talking about someone that is doing a work for hire, they usually don't have a lot of leverage, and they usually don't have a whole lot of ability to negotiate. And so when you talk about dispossession and inequality, what you're talking about generally are people of color that are at the mercy of people with more money, more leverage, and more power. So I think that would be my starting point. And beyond that, I do not have a case example, but I welcome the article that you will be writing about this.
Thank you so much, Professor Watts. And that's a
Thank
great
you.
transition for our next segment here, which will feature Professor KJ Green. So KJ, if you would unmute, thank you. Here's my question for you. Walk us through African-American music history. How have foundational artists of color in the United States music industry been economically exploited through inequitable contracts and divested copyrights in ragtime, blues, and jazz up through hip hop? And what should be done about it?
Thanks for that question, Jeff. First of all, before I address the question, I want to thank you and Roger Williams and also the Copyright Society. Actually, you guys are going to be publishing my article coming up next year on copyright termination. So just fabulous job putting this together. I also want to acknowledge my fellow panelists. I'm excited to hear what you guys have to say, maybe more excited than what I have to say with Angeli Vatz, who's Professor Vatz is one of the rising young stars in the IP space. And have been in conferences with her, just extremely glad to be on the same panel with you. Also meeting Tarika and looking forward to hear what you have to say, another young rising star. And of course, I have to acknowledge my good friend Latif, who is really been at the center of this whole discussion, really at the foundation, really, of this whole discussion. Both he and I were talking about this when this was just like a glimmer in somebody's eye, right? We're going back 20 years. And, Latif has been an amazing inspiration for me, not only as a scholar, as an academic, but as a human being. So, and we've been on numerous panels. We've had a lot of fun together. But when I speak, I always try to acknowledge you, Latif, because you really are like one of the, the main pioneers of this whole field. And most of us wouldn't even be here if it wasn't for you. So just, much respect and love to you for your work in this area. So I'll answer this question. I'll come at it this way. You know what? I think I'm going to play a song. Is that okay?
Absolutely.
I love the drop. So of course that song is Round Midnight. The composer is Thelonious Monk, but Thelonious Monk didn't own the copyright to Round Midnight, which is maybe the greatest jazz standard. Thelonious Monk is our African-American Beethoven, right? A genius. And negotiating these questions, as Angeli laid down so nicely in the beginning, of how is it that our greatest geniuses don't end up owning what they create in a system that's supposed to protect that? Because that's what copyright's supposed to do. And I raised this because when I started out in this field, Jeff, nobody was doing this work. Latif was out there and me. It was just you and me, buddy, in the beginning, and that's the truth. We were ostracized. We were not invited to conferences. We were, not welcome at AALS and all of these things because we were talking about this. And we were asking this question: how is it that you justify a system with your highfalutin, copyright incentive theory and the like? And, Justice Holmes said the life of law is not logic, but experience. And for people like Latif and I who looked at this, this is not our experience. All the things that you guys are talking about in these IP conferences, they don't line up with what's happening. And the other thing is you can't ignore it because African Americans are arguably the most innovative, certainly in the music space, that there is. The whole American music industry is built on African American music. You talked about women and their role. Don't forget about Black women. Black women are women too. And there was two women who launched the American record industry. Mamie Smith in 1920 with Crazy Blues, and a few years later, Bessie Smith, who floated Columbia, which is Sony today. They wouldn't be a Sony corporation today if it wasn't for Bessie Smith. So we looked at this and we said, how is this? You're sitting here and you're discussing all these abstract theories and doctrines of copyright law, and you're not talking about us and our contributions at all, and you can't do that. And we got fed up and we continued to write about it, right, Latif? And we continued to fight And now the world has caught up with us, Latif. Do you realize that? It's kind of a beautiful thing, right? It took 20 years almost, but it took that long for it to happen. So, you know, right now, this is an argument in the academic circles between distributive justice. But I say it's not distributive justice, it's wealth extraction. We have to acknowledge that. And Angela, you said that pretty much. This business, the American music business, is about extracting wealth. And specifically, historically, it has been about extracting the wealth of African-American artists in the business. And so looking back, we have to have some sort of accounting for that. And by the way, these are serious conversations that are going on now at very high levels about what the accounting will be. And by accounting, I'm talking about, you can call it redress, you can call it reparations, you can call it what you want. That has not been done. The American music industry has never apologized for the discrimination and the extraction of wealth of African Americans. That would be a good start. But number two, we're going to have to talk about money about this. And by the way, the labels recognize this. That's why Universal Music pledged $100 million to projects in the African American, no, I'm sorry, wrong. It wasn't Universal, it was Warner Brothers. Universal, who's much bigger than Warner Brothers, as we all know, pledged $25 million. And we're all like scratching our head. It's like $25 million? Drake makes that in an hour for you. That is not reparations, by the way. $100 million or $25 million is not reparations. These discussions are going on at a very high level. I noticed that the brother over, I think the brothers at Warner Brothers, Sony, one of them, he also now has a task force to discuss this issue. So they've kind of gotten the memo. Now it's taken a while that something's going to have to be done about how these African-American artists from top to bottom were fleeced. When I hear that James Brown, who was the greatest soul artist of all time, James Brown and his lawyer, I spoke to his lawyer, he had a 3% royalty rate. That blew my mind. I also didn't know that Monk didn't own Around Midnight, and he was snookered out of it. And so the question becomes, history of African-American music, why do we allow this? All right, and why do we have a system that says it protects people, but it doesn't protect people? And that's the question I've been asking almost for 20 years. And finally, maybe we're getting to a point we can have some answers about those questions. IP theory does not capture our experience. Yes, the copyright law, as Angeli says, and I wrote about this eons ago, doesn't mention race in any specific section, yet it is racialized all throughout. I talk about the 7 deadly sins of copyright, right? I made it 7 just because that sounds sexy, whatever. We could probably pick more, right? And this is embedded in the fabric of copyright, and it is hostile to African-American cultural production, which is something that has to be addressed because American culture is nothing without African-Americans. I think everybody recognizes that. You couldn't watch TV, you couldn't listen to music, you couldn't talk, you couldn't dance. There'd be so many, if we had a patent on everything that we created and you had to get permission from us to do it, there wouldn't be a lot that you could do, not in this culture, right? And so, you know, it's something that is not a fringe issue, which I was put on the fringe, and I think maybe you were too somewhat. I don't want to speak to you, Latif. They put us on the fringe. Oh, that stuff's over there. These are the black guys talking about the black stuff. Let them go on. No, it is at the center and at the heart of copyright law, right, that we're talking about. And now the realization is coming to that. So part of looking back in terms of the history and the taking that happened is that there's going to have to be some recompense for that. You're going to have to compensate people in some way for that. And I'm writing a piece now. I've written a piece actually about copyright terminations. And yes, it's a reformist type of thing. My kid's 20 years old, and he's like, oh, Dad, you're such a reformist, right? I mean, that's the worst thing that you can be called, right? But my whole thing is, look, if I can help somebody today, I will. I mean, we're not going to tear down the whole system tomorrow. So what can we do for people now? And of course, the copyright termination provisions were designed for just that. They were designed for artists who were taken advantage of early in deals to be able to recapture their work. The problem is that the system is set up so that virtually no one can do it. Prince was able to do it, for example. Sir Paul McCartney, a billionaire, could do it. But ordinary artists don't even know about copyright termination. I've run against iconic hip-hop artists just in the last few years who had no idea that they even had this right. So looking forward, that could be something. I also believe that we need extensions on statute of limitations so people can file claims. But we need a lot more than that, right? This is reformist, right? We probably need to completely re-examine how copyright law is treating artists generally. And that's basically what the larger project is that we've been talking about. But, you know, for example, the fixation doctrine has hurt African-American artists because we don't fix things. And if you want an example of that, think of the blurred lines case. right? And the Blurred Lines case, Robin Thicke and Pharrell caught a pass, didn't he, on that one? We only talked about Robin Thicke. The question was whether they copied Marvin Gaye's song, Got to Give It Up. And when it came to the court said, well, in order to make that determination, we're not going to let the jury actually listen to the record. Well, why not? Why can't they listen to the record? Because that's not the copyright that's at issue. The copyright is the composition copyright. Well, how did that copyright composition get created? Certainly not by Marvin Gaye when he went into the studio. Marvin Gaye went into the studio as black artists did. He jammed, right? And he popped out that song. By the way, he didn't want to do it. He only did it as an FU to Motown because they wanted him to do a disco record. Lo and behold, it became a #1 hit for him. And after they jammed, which is how African Americans make music, then somebody from Warner Brothers said, hey, man, you need to write down that song so we know what's going on here. That's what they did. And so the Blurred Lines case isn't about what was written down after he did the song. The Blurred Lines case is about the performance. And by the way, that's another one of the 7 deadly sins, that performers are treated absolutely horrifically. If you're not the composer of the song, and African-American music, I believe, and we could debate that, is really more performance-oriented than composition-oriented. So right off the bat, that is going to be a huge deficit for African-American artists. We can talk about formalities, and I've been hammering the drum and hammering the Copyright Office about this. Copyright formalities. Copyright formalities are always going to disadvantage people who are at the bottom. Derek Bell, critical race founder, said we should always look at the faces at the bottom. And that's what copyright law should do. That's what Lateef has been saying, and I've been saying forever. You got to look at the least of us. That's what Rawls says. He said you got to look at the least in society to see whether a legal system in a society is just or not. We're not doing that, and we need to start doing that. But of course, all of these things are something that we could explore further. I don't want to monopolize the microphone. How much time do I have left to speak?
3 minutes, but I've got a follow-up. How about your 7 deadly sin number 7, hostile judicial interpretations? Can you speak towards that?
Yes, and I'm glad there's some judges here because they probably don't get to hear this very often. Look, judges in the United States are by and large male and they're white. And this song was germane to this. I'll just give you an example of this, and then I'll lay off the songs. But everybody knows me. I love to play music, right? That's kind of like what I do. So I can't get around it. So low, you can't get under it. Get up so high, you can't get over it. I can't get over it. This is a chance to dance. That is the great George Clinton. The song is One Nation Under a Groove. And of course, a few years ago, I never wanted to know anything about copyright terminations, by the way. And then I met George Clinton. And I worked with George Clinton, and I had to get on the termination train. But hostile judicial determinations. This case went up to the Ninth Circuit about 5 years ago. It went up to the Ninth Circuit. And the issue was the Ninth Circuit going to allow a law firm that Mr. Clinton owed money to take his sound recordings to satisfy his judgment, right? That goes explicitly against copyright law. There's a provision, if you want to know, it's 17 U.S.C. 201E. It's a very obscure provision. And when we went to the Ninth Circuit, it seemed to me, first of all, I don't think the Ninth Circuit knew who George Clinton was. I don't think that the Ninth Circuit realized what an unbelievable genius he is and how he's affected all the music that you guys listen to today, particularly hip hop. There's no hip hop without James Brown and George Clinton, period, right? And they looked at the copyright certificates, which Warner Brothers had done as work made for hire. And we said, no. These aren't work made for hire, right? It doesn't fit into either category of work made for hire. And I just thought the hostility of the judges of African-American artists has been quite stunning. And that's just, the Clinton case is just one example of that. And they prejudice things like rhythm, which is very important in copyright infringement cases involving Black music. They use doctrines like the de minimis doctrine to minimize African-American originality, saying that, that little short phrase isn't original. Well, hip hop is built on short phrases, right? Like in the Ludacris case, just like that. When I move, you move just like that. Can just like that be copyrighted, right, is the question in those cases. So all of these things look neutral on their face, but at the end of the day, the hammer comes down on the African-American artist at the other end of it. And I think we have a massive problem in America that we just have basically a judiciary which is completely unrepresentative of the people. And it shows, right, in the judicial decision-making and the like. And so a lot of work needs to be done in that area, or things aren't going to change as well.
Thank you so much, Professor
Yes.
Green. I'm so appreciative for all your thoughts.
I have now concluded my opening statement.
Yeah, if anyone has questions, please put them in the Q&A. We'll get to them at the end. So now, moving on to Terica's segment. Thank you so much for being here. Terica, a question for you. Let's bring it to the present moment. George Floyd, Breonna Taylor, Black Lives Matter. What effect has the George Floyd protests had on the copyright world?
Thanks, Jeff. Well, before I get into answering the question, I likewise just want to thank you for putting together this panel. I want to thank the other panelists for being here. I think it's important that we are having these discussions. We're not necessarily all going to agree on everything, but I think it is important that we all share a common belief that artists of color, particularly Black artists, need to be protected. Their work should be appreciated, and they should be able to reap the benefits of the work that they, contribute to society. So I think it's important that discussions like these happen. So I just want to thank you, Jeff, for putting this together, especially as a 1L. I just want to throw that out there to anyone who does not know. Jeff put this together as a 1L, just starting law school. So thanks again, Jeff. But to get into your question, first of all, I think it's really important that you said those names: Breonna Taylor, Ahmaud Arbery, George Floyd. It's important that we continue to state those names and not forget about the people who have been, lives have been taken, Black lives that have been taken for centuries, really. But more specifically to your question, so I don't necessarily think that there's been a specific impact on copyright, so to speak, but I will speak about the art that has been produced in light of, Black Lives Matter and the atrocities that have been happening, as well as the push to bring these atrocities more into the spotlight. One thing that I in particular want to point out is that, we're seeing works of visual art, we're seeing movies and documentaries, we're hearing songs that a decade ago, 2 decades ago, 50 years ago, we never would have seen. And it's not because these atrocities are new. They've been going on. People have been expressing how it impacts the Black community. They've been expressing how it impacts society as a whole, but there hasn't necessarily always been an avenue for those messages to be put out on a platform the way that they are today. And so that's one thing that I have really noticed, in recent years as these protests have continued on. There's been a shift, and this kind of reminds me of a little bit something that KJ touched on a little bit ago about how, you and Lateef have been talking about these issues for some time. And, at one point you weren't necessarily given the platform to talk about those things. That's kind of the same thing that I'm seeing with the art that's coming out in reaction to this. And, one of the reasons that I actually got involved in copyright, a personal reason, is that I care a lot about social justice issues. I have a number of, family and friends who are artists in one form or another. And so I care a lot about protecting the work of Black creators. And so that is one of the reasons that I actually got involved in copyright law, because I actually see copyright law as an avenue for helping to amplify the voices of Black creators. And Black people more generally are often excluded from seats at the table for important discourse. And so a lot of the times, the way that we have historically been able to get our messages out in the wider sphere is through art, whether it's, the birth of hip hop, a genre that Black people created, Black people who are, from some of the poorest areas in New York who didn't necessarily have any other way to get those messages out. Today, 20, 30 years later, we have hip hop, which is the most prolific, most popular genre in the world. And so I see copyright as a tool to help empower those voices. And I think, in listening to Professor Green and Professor Votz, I hear some things that I don't necessarily agree with, but I also hear a lot of things that I do agree with. And particularly, I want to point out, I think we all agree that the actual impact on Black people, whether or not Black people have been able to own their works, whether or not they have been able to reap the benefits of copyright. I agree that, it would be impossible for anyone with any sort of serious position to sit here and say that that's not been the case. It's very obvious that that's been the case. But personally, I see that more so as a symptom of racist business practices, the larger issue of racism in society, and less so a direct result of copyright law in and of itself.
Thank you, Terica. A follow-up question. We saw at Universal, Sony and Warner pledging to give $225 million to racial justice initiatives in the aftermath of the murder of George Floyd. We saw Lady Antebellum and the Redskins changing their names. Are these proper remedies?
So that's a really interesting question, the way that you word that. So when you say, are these proper remedies, I assume you mean, are these proper remedies for racial injustice? And I have to say, no, there's no amount of money that can be donated that can rectify the long history of racial injustice and how it has hurt Black people. But to say, if your question is asking, do I think that those moves are beneficial? Do I think that they have some value? Absolutely. I think, if we're talking about reparations, as Professor Green touched on a little bit ago, I have mixed feelings about the whole concept of reparations and whether or not there ever can be a true monetary value placed on, the pain and the terrible history that Black people have endured in this country. I don't think that there is any monetary value that can be awarded that would take away or that could, balance the scales back out. But with that being said, I do think it is important that organizations and companies that are empowered, especially those that have been empowered on the backs of Black people, which are pretty much all of them, do have a place in making sure that, for instance, HBCUs are getting funding so that they can continue to produce talent, making sure that creators of color are, given avenues and given platforms to tell their own stories. And just to kind of go back to a little bit of what I was touching on before, one of the reasons that I see copyright as a tool for empowerment for marginalized communities is that when you are able to own your rights, we talk a lot about representation. That's been a big buzzword this year, especially representation on screen. What does it mean to be a person of color and, watching TV or listening to music or reading books and not seeing your experiences accurately reflected? When Black people have the ability to own the works that they create and to have a say over, that work from start to finish, that is a huge piece of ensuring that representation happens in an accurate, in a fair way, in a way that genuinely allows our stories to be told. There's a history, of blackface in film. There's histories of, records being taken from Black artists and given to white artists. And each time something like that happens, it produces negative stereotypes about Black people. It changes the message that is intended from, the original artist out to the public. And so I do think copyright ownership is really, really important for artists of color. And I also wanted to bring up a recent article that was published in Billboard actually a couple of days ago that Lateef and I were both actually quoted in. And it was about Jaquel Knight, who's a choreographer who choreographed one of his most popular pieces, is a little song you may have heard of called Single Ladies by Beyonce. He choreographed the video to that. And the story was basically about how he is the first commercial pop choreographer who has successfully registered his work with the Copyright Office. And, one thing that really, really stood out to me about the article, it was part of the article where they blow up a certain sentence and kind of emphasize it. So there was a sentence where he talked about how, he puts in the work as a choreographer, but, at some point he's not going to want to be dancing and he's not going to want to be having to teach these choreography classes or teach, artist choreography. He wants to be able to benefit from the work that he's already put in and see that benefit passed down to his children and his heirs. And, that to me is one of the most important parts about copyright. I hear a lot of people talk about, the length and term of copyright is too long, and why does it need to be life plus 70? Why can't it just, end when the person dies, or why can't it just be 20 years long? And, to that I say, in this country, there is no industry that has not benefited on the labor of Black people. We have seen for centuries Black people's labor being put in and our heirs not reaping the benefit of that labor. Other people, white people and their heirs for, decades and decades. We talk about the racial wealth gap. These are the kinds of elements that contribute to that. Black people spending their entire lives putting forth labor, but not having anything to pass down to their children. And so when I hear artists talking about how copyright ownership, this is something that Jay-Z talks about a lot. I'm a big Jay-Z and Beyonce fan, so you'll hear me talk about them a lot. But especially, since Jay-Z has become a father, a lot of his lyrics talk about the things that he's putting away for his children, the money that they will be able to have because he owns his masters and because of the other intellectual property title and all the business ventures that he has entered into. And so I think that's a really, really important part of copyright, and one of the main reasons that I see it as being a tool for empowerment and also a tool for helping to rectify some of the situations in the past where we see Black people putting in the work, a work becoming wildly successful, and those people dying broke, not having anything to show for it, their children not having anything to show for it. And, KJ, you touched on, judges and how most judges are white men. And, I completely agree. I think that there's a definite need for diversity, not only in the copyright bar. We need to make sure that copyright attorneys can understand the needs of creators of color. We need to make sure that the judges who are interpreting these laws and these cases do so in a way that is reflective of diversity that exists within the country and within artistry. There's definitely, you can see it in various case law, a disconnect between the background and maybe the experiences of a judge who's looking at rap lyrics or who's looking at something that they just have no experience with. And I'm happy to say that at least we see that happening less so now than we did probably 20 or so years ago. That said, of course, it's not gone. It's nothing is, in an overnight changed. But I definitely think that as we continue to have these discussions about the importance of diversity, the importance of considering race, no more of this, we don't see race, the importance of seeing race and seeing the implications of race, I hope that we can continue to address the racist business practices that contribute to these disparities, as well as the, inability for judges to actually interpret the law as it is designed to be interpreted.
Jericho, a follow-up question I noticed while you're speaking towards Jay-Z and Beyonce. What about responding to Professor Green in the sense of those seem to be faces on the top? Does copyright law equally capture those faces on the bottom?
So I would say copyright law itself does equally capture those faces on the bottom. Obviously, Beyonce and Jay-Z are by no means, exemplary of the experience of most people, period, especially most Black people. So I don't mean to suggest that, these are examples of how everyone's going to do under, the laws that exist in this country. But I do think that what is important, and one of the reasons that I am passionate about copyright law, and I'm passionate especially about educating creators about copyright law and how it can be used to their advantage, is that, Professor Green, you touched on termination, and you're saying how, artists that you would think would be aware of termination and how they can use it to their benefit, just don't know about it at all. And, that's one big goal that I have, is making sure that artists of color are being educated to understand how copyright can and should be used to empower them to build up their portfolios, to make sure that, if and when that 35-year mark comes and they want to, terminate some of those agreements, that they can do so. It's important. I think education always, is an important tool for anyone to have, but especially when it comes to creators being able to own their power, own their voice, and make sure that their work is truly reflective of, the intent of what they put out there. I think education is a big part of that.
And just as a last, sorry, going over the questions, but what about in terms of, I know Professor Green told me a lot about, but there's, if for one of these old school hip hop artists to get past that termination, they've got to go through all kinds of hoops in terms of paperwork, in terms of legal fees and so on and so forth. How do you respond to that?
Yeah, so I mean, I don't disagree that termination can be a very complicated area of law. That's not lost on me at all. But I do think that, with proper education, with the proper assistance, whether it be, an attorney, pro bono assistance, legal clinics, educational materials being put out by the Copyright Office, educational materials being put out by the Copyright Alliance, to help these creators to understand how to navigate termination. I think that's really important. I do agree that when it comes to looking at any kind of disparities in this country, or any kind of difficulties that people in general face, you can always assume correctly that those affect Black people even more. But in my opinion, I don't see that as a symptom of copyright law itself, because I do believe that even for a white artist who, is an independent artist who doesn't have, the backing of some major corporation or, high-powered attorneys, also struggle to, understand termination and to make that work. So yes, I do see Professor Green's point about, how when we're looking at society and how it all stacks up, oftentimes you are going to see Black people on the bottom. That has always been the case in this country. And I think that there's a lot of work to be done to make sure that when we're talking about helping people, that we are looking to the people who are the most affected, most negatively affected, and working our way up from there.
Thank you so much, Terika, for the thoughtful answers. We'll move on now to Professor Mutima. So many of the other panelists have already introduced you, so I let their words speak for mine. My question for you is as follows. How does this specific question of race fit into the greater IP social justice lens?
Okay, well, first let me make sure I can be heard, because I can never get this stuff right, but it seems like I can be. And I'd like to start off like everyone else and just first off, thank you for putting this together. I even happen to know that you started working on this before you were a 1L, because we met before then. So he's even greater than you think, right? Also, would also like to thank and acknowledge my fellow panelists, because really, what you've assembled here through this particular group is that you basically covered the spectrum of the issue. KJ was the scholar who first introduced these issues into mainstream copyright scholarship, right? He brought a lens to this that really forced people to have to, at least in their face, acknowledge that there were problems of systemic racism in copyright, in the music industry, et cetera, et cetera. And interestingly, we have what I call sort of the bookend of, once that is acknowledged, well, then you have to think about, okay, so how do we deal with the problem of race in the copyright system? And it becomes immediately clear that it is representative of the way in which race functions in our society as a whole. And it's the critical race scholars that began to turn their lens towards IP and copyright. And of course, we have Anjali Batts and her frequent writing partner, Deidre Keller, who's not on this, but they have done some fantastic work of applying the lens of critical race theory to copyright and to intellectual property in general. And so you sort of have it like on either end of the spectrum. But then finally, I think, as what has begun to become evident through this conversation, that another important part of dealing with this issue is that we can't limit our focus on theoretical scholarship, right? Theoretical scholarship is where you identify the question, you articulate what the problem is, and you bring it to those people who can bring about change, right? But similar to the civil rights movement, and when I write about this in my first book, I write about this from the perspective of, in order to bring about IP empowerment, IP social justice, we have to construct a movement that is very similar to the civil rights movement. And the civil rights movement was both tactical and theoretical on the one hand, but it was also strategically grassroots on the other, right? Charles Hamilton Houston, on the one hand, created the legal strategy, but then in his evening job at the NAACP, he helped to formulate the grassroots strategy that got the people involved, right? And we have to do something similar here. And that's why I'm so glad that we also have Terica Carrington on the panel, because as a practicing copyright lawyer who also works in the policy space, right? Because that's the other part of the spectrum, right? We've got to go from theory to activism, right? And a big part of activism is education, right? So to bring this to your specific question of where does race fit into this larger question, because it is a larger question. It's not just about, what's the relationship between copyright and racial justice. It's because we have other forms of injustice in the copyright ecosystem, right? We have the systemic derogation of the contributions of women, right? That's typically characterized as arts and crafts. It's not serious expressive work until men take it over, like dance, right? We have the systemic failure to protect, or for that matter, respect certain indigenous forms of creative expression, right? So we don't just have one social justice problem in copyright or in the IP system. We have a range of them, right? And the problem of racial injustice, okay, is a very particular one. But as I've been writing recently, in fact, as some of you know, I'm working on this book, and literally I was writing today, that one of the things about racial injustice in copyright is that it runs this gamut, right? As KJ remarked earlier, right, when he's talking about Black women artists, right? The problem of racial injustice covers virtually every type of injustice that we see in the copyright system. And so basically, it's one of the areas of injustice that we have to tackle. Now, tackling it as a problem of social justice, and the reason that in my work I approach it from that perspective, is because when I was in practice and working in the IP space, what struck me was that as you presented these problems to other IP practitioners, judges, experts, et cetera, what was really interesting was that it was not that they denied the existence of racial inequities in copyright or in IP. And it wasn't even that they thought, oh, well, it's not a bad thing. Like, everybody seemed to agree that, yeah, there are these horrible historic traditions in the music business, in other parts of entertainment, et cetera, and it's awful and they're bad, right? And so I was a bit perplexed. So why doesn't anybody do anything about it, right? And one of the, law and policy responses to that was that, be it copyright or some other part of IP, but copyright, it's not about social justice. It doesn't have anything to do with that. Copyright is exclusively a system of economic utility. It is a system of providing economic incentives to bring about particular results in the IP space that can be measured through economic metrics, right? So in effect, right, the presumption is you will get the best qualitative and quantitative outcomes. You will get the most IP and the best IP if you just talk about money, right? But now we see where the deficiencies come about. It is not that copyright is inherently or irreparably, and that's the key word, irreparably, horrible and misogynist and racist, et cetera. The key issue is, what do you demand of the copyright system? If all you demand of it are outcomes and effects that can be measured solely in terms of economics and solely in terms of a very narrow band of economics, because we're talking about things that resonate, that make money, particularly in the commercial marketplace. If that's all you're looking at, then you're leaving a lot of stuff off the table, right? So you're not thinking about artists who aren't motivated by money, right? That's left on the table, right? You're also not thinking about the type of IP outcomes that are not commercially successful, right? Right. So if you're going to do expressive works that relate, for example, to African American history, right, or works that speak to women, right? Well, if those things aren't particularly successful in the commercial marketplace, then copyright doesn't need to encourage them. In addition, you could have copyright inequities, racial injustice, gender injustice, or what have you. If they don't register economically, and again, narrow economically, right? They can register economically to the people who are cheated, but if they don't recognize in terms of the industry as a whole, right? What do you mean there's an economic problem? Don't we have a gigantic music industry, right? Okay, so then you don't have to care about that stuff, right? So the real problem is asking oneself, okay, what is the relationship between copyright's social purpose, promoting expressive endeavor? What's the relationship between that goal and the goals, progressive goals of racial justice, social justice writ large? And what struck me was that the basic answer, right, that was the predominant thought throughout most of the 20th century, was that these two have nothing to do with each other. Well, before we were going to be able to correct these problems, we had to get rid of that perspective. We had to answer that question. We had to say that no, not only is copyright not agnostic towards social justice, but actually social justice is absolutely essential to copyright fulfilling its purpose, right? Now, if you can establish that, it means that, wait a minute, copyright can't tolerate racial and other injustice, right? Copyright must, where we see racial and other social injustice, copyright must do something about it, right? And the way in which we establish it, for most of us, it seems pretty obvious, right? Copyright and other intellectual property endeavor, it is by its very nature a crowdsourcing enterprise, right? You get the best and most ideas by making certain that the net that you cast is the most inclusive, right? Right? The most equitable, right? I mean, one of the metaphors, and for those people who may have been a part of the Mosaic conference that I do every year and that we did just a week or so ago, my favorite metaphor is that, if you were the captain on an ocean liner heading towards a whirlpool and you got like about 10 hours notice, right? And you say, we need ideas. We've got to figure out, otherwise we're going down. You're not going to say, well, I only want the ideas that come from first class, Forget about steerage, right? No, you want every idea you can possibly have. And you want to create a system that is inviting to everyone who could possibly contribute an idea. I mean, if I'm sitting down in steerage and I know that the way the system works is that, well, no matter where the idea comes from, the only people that are going to get to the lifeboats are the people in first class. I don't know that I want to work in a system like that. I don't know that I want to contribute to a system like that. So once you understand that copyright and intellectual property as a whole, it is an inherently crowdsourcing enterprise. It is something that needs everyone to participate, everyone to be treated equally, everybody to feel that the rewards and the incentives, their voices, everything is going to be heard equally, right? Now you understand why it is that any form of copyright injustice actually harms the copyright system, right? And when it comes to the particular problem of racial injustice, this is where the work of KJ and Anjali come in so perfectly, because once you've established that threshold, that social justice is essential to copyright, well, now we can look at each particular problem and ascertain what's the particular source that we look for proper remedies to that problem. Because social injustice in the copyright space is not one size fits all, right? The way in which we address racial injustice in copyright might not be identical to the way in which we address gender injustice, the way in which we deal with the failure to protect traditional knowledge and expression, right? And so what happens, you start with the foundational bedrock of IP social justice, that the system must be based upon socially equitable principles of equitable access, inclusion, and empowerment. And once you accept that, once you understand that that's essential to copyright working properly, now when someone presents to you a problem of copyright injustice, racial problem, gender problem, non-Western problem, now you know you must deal with it for the sake of copyright. And now you look to the particular mélange of solutions, right? So for race, it might be critical race theory, you know. For gender problems, it might be critical feminist theory, whatever. But then that's how you fashion and you customize the particular remedy. And last thought, in addition to while you're doing that, as I said at the outset, you've got to be careful to not only focus on the theoretical or the top-down aspects of it, right? Not just in appellate court, Supreme Court opinions. You've also got to think about, how do you raise the awareness of the people that are being affected by this? So you have to bring in the work of people like Terica Carrington and the Copyright Alliance and other entities. You've got to get this to the people, right? So that people begin to be educated, that they begin to understand, right? Hey, copyright is a thing that is out there that has been used against us, but as some of us, as Terica was referencing Jaquil Knight, some of us have begun to recognize, but wait a minute, now that certain changes have come about in society, perhaps we can start using this tool in our own behalf and follow the example, as KJ would immediately point to, of people like Ray Charles, right? Who understood the power of owning the copyright of your masters, right? And then got it back. So that's where I would place racial injustice along other injustice in this whole spectrum of copyright social justice writ large.
Thank you so much, Professor Mattino. I know that Terica has a comment towards what you have to say, so Terica, go ahead.
Yeah, so Lateef, when you mentioned, the role of policy, it actually brought to mind the CASE Act, and I just wanted to take a little bit of time to just talk about, the role that I see the CASE Act playing in the conversation that we're having. So for those of you who are not aware or familiar with the CASE Act, it's the Copyright Alternatives and Small Claims Enforcement Act. It's designed to create a small claims tribunal for copyright disputes that would be housed in the Copyright Office. And just for a little bit of quick background, because we need to move on to Q&A, but the average cost of litigating a copyright infringement case in federal court is close to $400,000, which I don't know anyone who has $400,000 just sitting around, maybe Beyonce and Jay-Z, but most people do not have $400,000 sitting around that they can use to enforce those rights. And so, the CASE Act is something that I've been working on for a few years now at the Copyright Alliance. And I know there are a number of organizations that are, supportive of the CASE Act, including IIPSJ. But I truly see the CASE Act as being a bill that is designed to try to bring some social justice and to a system that is not necessarily designed to create injustice. I don't think that when people, when it was written into copyright law that, copyright disputes had to be litigated in federal court, I don't think that it was in anyone's mind to make it difficult for individual creators to be able to enforce their rights. I definitely don't think it was in anyone's mind to make it more difficult for creators of color to enforce their rights. But unfortunately, that's the result. Most people cannot afford to enforce their rights unless they are a major corporation in federal court. And so what the CASE Act would do is help to basically create an avenue for that kind of enforcement for creators. And something that is a bit ironic, I find, about some of the organizations that are against the CASE Act or that have come out in opposition to the CASE Act. Many of them purport to represent the public interest. I think it makes you question, okay, well, whose interest? I mean, the public is a vast entity. There are so many different, pieces that make up the public. And so, you would expect that organizations that are trying to help the public interest and trying to help people, be able to enforce their rights and to be able to have access to justice would be in support of that. Unfortunately, some of them are not. But I definitely think that the CASE Act is a big step in the right direction to helping to address some of these disparities that we have discussed so far on this panel.
And, if I could just tack on to that, I think this is the reason why the perspectives advanced by each of the other panelists all are all accurate, right? In other words, the real problem with the unduly narrow economic focus of thinking of, as someone in the chat pointed out, of thinking of progress of the arts and sciences only in very narrow economic terms, is that it blunts you to not only other needs, but to various problems, right? And so it presumes that, first of all, that internally, like the particular provisions of copyright, that they're completely objective and fair, right? And as Anjali demonstrated for us at the outset, that no, they aren't, right? Here are ways in which these provisions, they may seem to be neutral on the face, but actually they aren't. And one of the cases that KJ was talking about, there is a provision, for example, in the Copyright Act that deals with performance rights and the reasons as to why the creative artistry of the performer does not get a protection under the Copyright Act. And another friend of ours, another IP scholar, Bob Browness, has done some great work in looking at the case where that all started. And there is like blatantly a racial language in the case that years later, people who hadn't read the case was unaware of. And when they codified the more or less essential holding of the case into the Copyright Act, they didn't even realize that that's what they were doing, right? But then there's another thing that you get blunted to with this unduly only economic and very specific narrow economics, is that it also blinds you to the fact that not only are the internal provisions of copyright not as, quote, economically neutral as one would like to pretend, but there's also this notion that, well, as a purely economic mechanism, it is immune to any external racist and other social injustice thinking, right? And of course, how could that possibly be? How could you create a system, let's assume for the moment that it is neutral, which you've already established that it isn't, and put it into a society that, for example, we have an institution called Jim Crow, right? And somehow or another think that those neutral provisions, right, are going to be implemented in a perfectly neutral and fair way. So what we see here, right, is that, yes, copyright has racial deficiencies that arise both from conscious bias, some from disparate impacts, right? What KJ was talking about in the Blurred Lines case. To date, so far, I'm unaware that when the Copyright Office developed that policy, that the registration deposit for musical composition has to be in written music notation, and you can't just submit a recording, right? I'm not aware that they were specifically thinking about, and this is how we screw the Black artists, okay? But the results were that not only did it disparately impact Black composers, but it ultimately impacted a wide variety of composers in virtually every American genre, right? One of the things that we submitted, the Institute submitted an amicus brief in the Blurred Lines case. And one of the things that we pointed out was that what that policy does, it overlooks composers who perform in the phrase that we coined in the brief, what we call the oral tradition, not oral, right, to distinguish, right? And this basically references musicians who learn to play and to compose by ear. And if you were to look at the list of American composers, I was just looking at it today for part of the book that I'm writing, we're not just talking about Black composers. Sure, Marvin Gaye was on that list. Irving Berlin is on that list. Glenn Campbell is on that list, right? So what does this establish? It establishes that if you do copyright injustice, it's ultimately going to impact copyright social utility as a whole,
Right. Another way of saying that, what's good for copyright, what's good for African Americans is good for copyright.
Exactly.
I just want to chime in on this
about it the right
discussion,
way.
which,
Yeah,
which
no.
is great. And I just want to say, yes, on this neutrality issue, so take registration. Last year, the Supreme Court in the Fourth Estate case so casually, so cavalierly said, oh, sorry, you've got to register, bro. If you don't have a copyright registration, you ain't walking in here.
Right.
That crucifies African-American artists. You've worked with these artists. I work with these artists. They don't register. Everybody on the planet knows they don't. That's an impact. But the other side of that, and this is to respond to some of the things that Tarika was saying, the system is garbage. It's garbage in, garbage out. If I could have a wish list, one of the things would be a complete audit of all the records of the U.S. Copyright Office. Because Copyright Office, they tightened up in more recent years, I think, because of my ranting and raving. I like to think that. They would register a hamburger, right? Well, they wouldn't register a hamburger, but anything more than that. Not only that, there is no verification of all those copyright records. That's what I'm saying. This system is rotten. All those copyright records mean nothing to me because we know that many of the people who are on those copyright certificates are not the owner of those copyrights.
Right.
And
Right.
historically, an African-American person is the true creator of it. So one of my wish lists for copyright reform would be a complete audit. Why doesn't the Copyright Office, like the Trademark Office, verify these registrations? The Trademark Office verifies every registration, and all of us who've done trademark know more than likely you're likely to get a rejection, 9 times out of 10 when you send it in. They are looking for reasons to reject your application. Why doesn't the Copyright Office do that? And I see this even now. This is not a problem of the past. Even now, where artists aren't on copyright certificates who are supposed to. Then it goes up the chain to BMI to ASCAP, and we ask them and say, wait a minute, why is this guy on the copyright? Our guy wrote this song. Who are these other people? We don't know who they are. Well, that's what was on the copyright certificate. Sorry. And so it goes up and down the chain. So there's so much change that needs to be done. But one thing, I think Tarika said she didn't disagree with me on some. One thing I would disagree with you on is it is not going to be easy to do this. And Lateef as well. The powers that be are invested in this system. They've done extremely well from it. And they're simply not going to give up the system. And that's why these big record labels now are trying to throw some money, which I say is throwing sand in your face, like in a fight, like here's some sand, and you guys can go away now. Or you can say, well, you're always asking for more. You're back to ask for more. We just gave all this money. And so the fight, and Lateef, you were probably better at this than anybody. The way you couch things, I'm terrible at it. I realize that, right? You don't want me at the front end of this, perhaps. Is that you know how to couch it so perhaps they could listen to it and digest it, right? And actually see what's in it for them. And so, hats off for you to doing that. But I see this as it is a system. The system exists for the reason it does. When they were doing the copyright termination, the copyright revision that became the 1976 Act, there wasn't a single black person in the room. There wasn't a woman in the room either. This is institutional racism. And you wonder why you have the outcome that you have.
Right.
Can I?
Can I just interrupt and then let Anjali speak?
I wanted to actually, and I think this is part of the conversation that we're having. I want to answer one of the questions in the Q&A. So this is a little bit confusing for folks in the audience, also for me, but there's a chat and a Q&A, and there's questions in both of those. I want to answer one of the questions in the Q&A, which was a black band won Campbell, and I think this is related to what both KJ and Lateef were saying, right? Like when we talk about the structural, we have to divest in the outcome of cases because, Lateef was talking about the Sound Recordings Act, right? Like if we talk about the Sound Recordings Act, that is a structural problem that applies to everybody that made music before the Sound Recording Act was passed. So to say Marvin Gaye won this case is to ignore everything else that happened, right? And so I think the same thing about Campbell, and I want to highlight that here because, we can look at Campbell versus Acuff Rose and we can say, oh, parodies are okay now, right? Or we can look at SunTrust Bank versus Houghton Mifflin and say, oh, well, the black author won, we're all good. Except, we all know that the fair use test is very fact specific, and it is often very judge specific, right? Because you can look at the district court opinion in SunTrust Bank versus Houghton Mifflin and compare it to the appellate court decision and say, oh, well, Georgia feels real protective right now of Scarlett O'Hara, right? And there's actually this line, this famous line about tainting Scarlett O'Hara's, race in the district court opinion. So I want to just caution against looking at outcomes as dispositive. And when Dean Keller and I were writing our article, which is called Critical Race IP, that article, we had a lot of conversations about how to basically disconnect from this problem of over-focus on the outcomes. And I think this answers another question. There's a question here about Clyde Stubblefield as well, and James Brown, and but he didn't get paid, right? And so, again, there's a kind of racial reductionism that happens there. Yes, that's the case. Clyde Stubblefield got sampled a whole bunch from Funky Drummer, and he didn't get compensated for it, but that is a structural problem. It's not a James Brown problem. And that's not to say, I can't speak to James Brown, as a person, but I want to make sure that we actually don't make these questions personal, that we recognize that sometimes even when people win, that the system is still broken, right? And the thing about blurred lines is T.I. and Pharrell are on one side and we don't talk about them for a whole bunch of reasons. I actually start and end the book on blurred lines. But people want to tell the story of Marvin Gaye because Marvin Gaye he's a callback. He's a callback to civil rights victories, right, in Motown. And so that is a compelling story. And I think we want to be attentive to what sorts of narratives are compelling, what sorts of stories win, and how they get used as a bait and switch for the structural problems that continue to exist.
Yeah, in fact, I think that's a very good point because, from an IP social justice perspective, what you have to do is you have to look at not only individual outcomes, but systemic conditions and ask, okay, what impact do these outcomes and these conditions have on copyright social utility as a whole, right? I mean, if whole cohorts in society are being excluded or treated unfairly within the copyright system, well, that's going to harm copyright utility as a whole. And so we can't just think about an individual, okay? We have to think about it writ large. But then we go from that, and then we also have to then move to the next step and just simply recognize that, IP social justice may be a theoretical perspective that gets us to the point that these issues no longer have to be debated, right? But everybody understands that, okay, this is absolutely essential. But then you have to move to actual boots on the ground, what I refer to in my book as IP empowerment. And IP empowerment means changing specific outcomes, right? And adjusting the law in terms of the way it is actually implemented and amended, i.e., for example, things like the CASE Act, and educating, right? One of the big parts of what we do at the Institute is that we regularly hold IP education programs, right? Because people out there need to know, artists out there need to know, right, that they're imperfect though it may be, right? There are mechanisms out there that if you're aware of them and utilize them properly, you can begin to turn the needle in another direction. Now, again, that's not to say that, mere education alone is going to deal with many of these systemic, problems. But again, that's what we're talking about. It's dealing with.
You help everybody that you can while you're trying to tear down the system and rebuild it, right?
Exactly.
I agree with that. You have to try to do that. I mean, we watched the rallies with YMCA being played, but the person who's laughing all the way to the bank is Victor Willis after a very nasty, lengthy copyright termination fight, which almost no one could afford, by the way. I don't know how he got that financed. Yes. He was able to wrest back his copyright in YMCA, Macho Man, and all those other songs. But the people don't know the backstory. I'm always interested in the backstory. The backstory was that there was somebody on the copyright certificate that was filed in the U.S. Copyright Office who was not a composer. The other French guy, he had nothing to do with the song.
Yes.
And I'm saying, I want an audit of every file in the Copyright Office to make that determination. Are these people really owning it? Because the people who end up on the short stick of that are always going to be people from the African American community.
Yeah.
And so now,
and such an audit, it not only benefits marginalized and copyright disenfranchised creators, but it benefits the copyright system, right? We have a better, more accurate system that is doing what it's supposed to do. I mean, I think the underlying problem here is that in theory, copyright is supposed to do some wonderful things. Historically, it has gotten off the rails and done some horrible things. And I think my perspective is, okay, how do you readjust that, right? In a meaningful, down to the meta level way, right? And I think that, maybe we disagree a little bit is whether or not that's possible, right?
I don't know if we disagree so much.
Right, exactly. I mean,
but
right. I mean, I think
I want people to know, because I deal in the academic medium, and I want academics and judges too to know this hurts people. Exactly. This hurts people. It destroys people. Thelonious Monk, after learning that he had lost the rights to his signature song, he didn't want to play it ever again. A lot of people don't know that.
Yeah.
This is deeply impactful on people. That's one aspect we haven't discussed. The moral rights or the personal issue of it is extremely devastating.
Yeah. And in fact, one of the things that you're talking about, through the audit, the Barrett Strong case.
Yes.
Is a great example.
Honey,
of that,
that's
right?
what I want.
Yeah. And in fact, the perpetrator in that case, to get back to Anjali's point about race reductionism, the perpetrator, was Berry Gordy and Motown. So for people who don't know the story, the original registration included Barrett Strong as, one of the authors, and he obviously was a principal author of the song. And later on, Berry Gordy goes back, files a new registration that actually takes Barrett Strong's name off, right?
Yeah, and he got nothing for 30 years.
Exactly. So clearly, an audit, but an audit is something that everyone who is, quote, pro-copyright, we would all be saying, yes, let's do this, right? And obviously, in order to audit the copyright system to bring about this result, well, you got to hold on to the copyright system. And in order to make the audit happen in the first place, you've got to make certain that people know that, hey, listen, there are options here for you. So we got to make that an option. And then we got to make sure that people on the ground are aware that option exists.
Thank you all so much. We've only have a couple minutes to go, so I'll just say my final thank yous, then I'll open it up if anyone has final comments. Thank you again to all the panelists and to all the attendees. Feel free to email me with feedback about this panel or to continue the conversation. I'm putting my email in the chat now, ipla@g.rwu.edu, IPLA. We're going to do one of these every semester, so we're starting to plan for the spring one. And with that, we have a couple more minutes. So, I mean, my question just to open it up is copyright inherently and irreparably racially discriminatory? But it's really just open up to any final remarks anyone has. So thank you so much.
Can I start with that one? The way I've been framing this recently is by highlighting 4 things. The first one, just essentially 4 questions that I think it's useful for us to ask and think about when we're thinking about copyright reform. So my answer to the question is no. I mean, I don't think anything is irreparable, but I'm kind of a softie like that. I think, though, that we have to have a method of thinking about this, and we have to have investment. We have to have a strategy, basically. So the first thing I would say is that the thing that critical race theory offers us is a realignment of ethics. And I think the first step is to think about what our ethical commitments are to race and social justice and what they look like in an IP space. The second thing I want to highlight is performance, the question of performance. So you asked the question, Jeff, earlier of Prince. I mean, a lot of what Prince was doing was legal, but a lot of what he was doing was also performative, right? And we're living in a very performative moment right now where in Donald Trump's reality, he won the election. And so, that's also a performative thing that's going on. So we know very much right now what the impact is of the performative, right? Like you tweet a thing, tweet with a filing fee, right? That is now a thing that makes reality, but also the performative matters. And so we can perform in ways that resist copyright. And I think that is a thing that Prince was trying to establish and negotiate in the world. And the third thing that I would say is that we have to take all of that, the ethical and the performative, and we have to retrain our lawyers. We have to figure out what it is we want to teach our lawyers and how we want them to practice intellectual property law and copyright law more specifically, how we want them to practice differently. And then I would say, I mean, and these aren't necessarily in a sequential order, but you have to know where you're ethically situated before you can make the legislative questions, right? And so that's the last thing I would highlight. I would say then there's this whole realm of the legislative. So, you know, there's, what I'm suggesting here is that there's all these different levels at which change is happening. And I'm kind of suggesting that like a traditional knowledge digital library like India's built falls into this performative category because it's extra legal, but also it has an impact on the legal. But you get the idea. I think it's just really important that we think through these questions strategically and recognize that people that, you know, to respond to what KJ said, you know, the 20-year-olds and 20-year-old me definitely also wanted to burn it down, also 30-year-old me and possibly 35-and-a-half-year-old me. And now I'm like, maybe that's not such a good idea, right? So I think that we have to think collaboratively and not think that reformism is necessarily the enemy of forward progress.
Great. Well, it's
Someone's
7
sticking up
o'clock.
for the copyright office in the chat.
Yeah, please.
I didn't see what the question was, though. I can't find it now.
I don't think there is one.
Okay, maybe it's gone now. Censorship, huh?
Maybe you scared them away, KJ.
Yes, at some point there's going to be IP martial law is going to be declared, right? We won't be having panels like this.
Well, thank you all so much. You know, I'll let people write any final comments into the chat before I end the session. But just what a great way to start law school for me and for all of you. I really appreciate putting you know, the time to share your ideas and thoughts with so many people. And this is recorded, so others will also hopefully get to hear of your ideas. Thank you so much.